to start. Ms. Warren won't be joining us, but I'll be in phone contact with her if she has an issue.
Okay, thank you. All right, with that said, good evening, everyone. I'd like to call the meeting to order. It is 6:40 or 6:35, 37. If everyone can please rise for the Pledge of Allegiance, and I'll ask Ms. Medina to lead us in the pledge. You'll pass it. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. My granddaughter would have loved to do this. Okay. And may we have a roll call of the board members, please?
Chair Member Roslin.
I'm sorry?
Roslin.
Here.
Michael McDermott. Here. Darlena Medina. Here. Blythe Pierre Lewis.
Here.
Evan Shields. Here. Nikisha Williams.
Present.
Patricia Longchamp.
Patricia Longchamp. All right, with that said, is it ready? Okay.
We have
If
four.
we have a quorum. Can you please make the announcement to the audience and explain the process of what's going to take place this evening?
Okay, Madam Chair. And first, I'd like to ask everyone to please silence your cell phones. I'm Gary Held. I'm the attorney for the board. This is a summary of the rules which apply to the items tonight, which are called quasi-judicial. And the reason they are called quasi-judicial is that they apply to specific parcels of land, like for variances or special exceptions that are on the agenda today. The board will sit like a court, hence the term quasi-judicial, reviewing the facts presented at the hearing, applying the adopted rules as explained by staff in the staff report and verbally. Board members can make site visits, but must disclose the evidence upon which they intend to rely from that visit. Board members will also disclose at the beginning of the hearing whether they have had communications with individuals on behalf of the applicant or other persons, including who the communication was with and what the topic of the discussion was. All persons intending to speak to the board will be sworn by the clerk. The staff will make a presentation, and then the board may ask staff questions. The applicant will make a presentation, including expert witnesses, if any, and the board may ask questions of the applicant or the witnesses. When the public hearing is open, the public can comment on the application, limited to 2 minutes each. Citizen testimony must be fact-based, not merely your opinion about whether the application should be approved or not. The board will then deliberate based upon the evidence presented. The board's decision must be based upon competent substantial evidence, meaning based on the record, staff presentations, expert opinions, and fact-based comments, not opinion, by citizens, according to the standards for approval set forth in the City Code. The board may approve, deny, or continue the item. While staff previously read into the record emailed comments, we have concluded this is improper in quasi-judicial matters, as the person sending the email is not sworn, and there is no opportunity for cross-examination. Written comments provided before the meeting are made part of the record and were made available for review by commissioners. Lastly, we ask each of you to treat this proceeding with respect and proper decorum, no calling out, interrupting speakers, or disrupting the proceeding. Please give this proceeding the same dignity as if you were in court. Disruptions are enforceable pursuant to the City Code. Thank you.
Thank you, Mr. Hurd. With that being said, the quasi-judicial oath will be administered. Anyone who will be speaking for or against or explaining your case is to stand up and take the oath before speaking tonight.
This would include all applicants who are asking for relief from the board on any application, and any citizen who wants to speak on an item on today's agenda. And the clerk will issue the oath. Please raise your right hand.
There's more people than that. I'm
Okay?
sorry,
You
tout
need to
moun,
stand up.
may I just, tout moun ki gen ka devan bod lan aswayan supposé lever pour yo prêter serment. And I can't say it in Spanish. Somebody will help me. If you're speaking, if you have a case tonight, you will be speaking in front of us. Please stand up and take the oath. Otherwise, we'll not let you speak. Okay, I got people up.
Please raise your right hand and repeat after me. I solemnly swear or affirm to tell the truth,
I swear and affirm to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
Thank you.
All right. Any amendments to the agenda?
No, Madam Chair.
Okay. Any communications, and we'll handle, I guess, case by case as we review them? Mr. Hurd? Yes? No?
Yes.
In terms of disclosing of communications, board members? Okay. No continued petitions. Okay, we'll start with the first new petition, which is V-03-22, which is fence height variance within the front yard, 1460 Northeast 123rd Road.
If I may, Madam Chair, for a moment of discretion for staffing purposes. We have our new planning tech, which is Isaiah Vassen. I want to introduce you to him. He'll be working with us now with the Board of Adjustment, serving as secretary. And we have the new planner, which is Cameron Palmer, which I believe many of you have had communications with, and things to that effect. I've had him come up and introduce himself a little formally, if you may, Madam Chair, to say hello to the board for a second. Mr. Palmer.
We get his email.
Thank you, Madam Chair and the board members. It's a pleasure to be here tonight. My name is Cameron Palmer. I'm coming from Toronto, Ontario, Canada. I've taken a position here as the newest member on the zoning team here at the City of North Miami, and it's a pleasure to work with you all now and in the future.
Thank you.
Welcome.
Congratulations, welcome.
Oh, and 1 minute, then I think I skipped on, it's been so long, and I'm sorry. Approval of the minutes from September 29, 2021. Moved by Mr. McDiarmid. Do I have a second?
Second.
Okay. All right, both, 2 seconds. All in favor, say aye.
Aye.
Any opposed? All right, thank you. Now you may go on.
I think we have the January meeting as well.
January.
Is it there?
I move to approve the minutes from the January meeting.
Thank you,
second.
Mr. Shields.
I second.
Okay, moved and seconded. All in favor?
Aye.
Aye.
Any opposed?
Thank you, Madam Chair. I'm Derek Cook, the acting zoning and planning director for the City of North Miami. The item before us we have is a variance for the property located generally at 1460 Northeast. And I'm out of order here.
Mm-hmm.
Okay. You'll forgive me as I try to get this back in order. So the item before us is the tattoo parlor. It's a special exception for, and generally located at 1675 Northeast 123rd Street. Special exception is pursuant to Article 4, Division 2, Section 4-202.
I'm sorry, Mr. Cook, I think maybe I read it out of order, because the first one there is 1460.
Your PowerPoint
Northeast
has a different order
123rd.
than the written agenda there.
Okay.
Yeah,
132nd.
That's it, right there.
Okay. As we move on with these technical difficulties, let's move back to the originally scheduled program. Thank you, Madam Chair. So the item before you is 1460 Northeast 132nd Street It is a variance for a fence, and I will read into record. The variance to Article 5, Division 12, Section 5-1209K3 of the Chapter 29 of the City of North Miami Code of Ordinance Land Development Regulations to allow a 25% opaque, 5-foot tall fence within the 10-foot setback edge to the driveway leading to the public right-of-way at the property located at 1460 Northeast 132nd Road within the R4 multifamily residential district. The said variance is to be reviewed under criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. So, in a nutshell, what we have here is a single-family home within the R4 district. An R4 district is a multifamily zone. In the multifamily district, we don't allow for fences to be erected along the property line at the front of the property. So in this instance, the applicant, which has a single family in the neighborhood is predominantly single family, they were seeking to have the same opportunities as any other single family within the R1 or R2 district to allow for their fence within the front setback at the property line. And within that confines of the code, we allow that in the R1 and R2 if the fence is not taller than 5 feet and they have an opaquity of no greater than 25%. In these two elements, the applicant meets that criteria. So they have a fence that they wish to have at that point, which is not more than 5 feet tall, and they meet the criteria of no more than 25% opaquity. And they are seeking relief to be able to allow to have this fence at that location. That is the application in its nutshell. Any questions for me? Yes, sir, Mr. Hill.
So I just want to try and correct the record a little bit. The title to this item in the agenda says 1460 Northeast 123 Road. The body of the item being read says 1460 Northeast 132nd Road. And page 3 of the staff report says 1460 Northeast 132 Street. While there I don't think there's going to be a jurisdictional issue. I think we can go forward with the application because the application itself and the full title have the correct address of 1460 Northeast 132nd Road. So anybody reviewing it in full would know the correct address. But I just wanted to correct the record for that.
Thank you, Mr. Hill. Sorry for the errors, the scrivener errors that took place within the confines of creating the application and the PowerPoints.
Good catch. Thank you. All right. Is the applicant here to speak on the matter?
Hello, everyone.
Hi. Use that mic?
Hi, can you hear me?
Yes. State your name and address, please.
I am speaking for the applicant. My name is Genesis Ramirez, speaking for Digne Andrade, which is my mother. She's right there, but she asked if I could speak for her. Yeah.
Okay.
And anything else before I start?
Did you want to add? Does mommy want to add anything?
Absolutely, yes. I want to echo what he was saying, that although it is a multifamily district zone, we are a single family, single mother too, and like those are my siblings there, and we just want a fence. We would feel safer with a fence. As you can see in the picture in his PowerPoint, we have a lot of windows and you can see practically everything in our home. And there are a lot of vagrants that kind of walk around the street sometimes, and we would just feel safer with a fence in general. There has been a break-in in our cars. In the whole road, there was a break-in about 2 years ago, and we didn't have anything in our cars, but they still went and picked at everything, and we had our cars inside of the sidewalk, but inside of our driveway area, and that could have been prevented with a fence and just minor things like that that would make us feel a lot more safe with a fence. And in our street, there's a lot of houses with a fence already, so it would aesthetically look good as well. And we're not getting, sorry, an ugly fence. We're getting, we would get a nice aesthetically pleasing fence as well, that would match the architecture of our house, so it would not be unsightly, and it would bring us a lot of comfort and safety.
Okay, thank you. All right.
Thank you.
With that, Mr. Hurd?
So I just wanted to supplement staff's presentation and their recommendation of approval in that this is an example of a single-family neighborhood that's zoned R4, and the R4 regulations are being applied. In other cities that I've worked for where there's that incongruity, sometimes you amend the code to recognize that there are certain aspects of the single-family neighborhood that should be treated as if it was R1 or R2, which would be like setbacks for fences. There's a later application today on the parking of an RV, which would normally be permitted in a single-family neighborhood, but because the zoning is different, and it's unlikely that this neighborhood would be redeveloped to a multifamily use, though I suppose it's possible that that's a zoning issue, but the recognition that there is a single-family neighborhood and these uses are present and probably should be treated as if they were zoned single-family. Just, so I encourage the board to approve the application.
Okay.
Madam Chair,
Well,
I'm sorry.
hold on. Thank you, ma'am.
Thank you.
What I want to do is stick to let the public hearing, and if there is none, then I'll open a board discussion. Anyone who would like, I'm opening up public hearing, anyone who'd like to speak in favor of or against this particular item, now is your opportunity to come up. Public hearing is closed. Board discussion. Go ahead, Mr. McDermott.
I guess to, yeah, it's on, conjointly to council and staff. So basically, if this was an R1 or R2, there wouldn't be an issue. Is that, okay, I think that,
Correct.
right.
Okay. Any other board discussion?
I'd like to move the item.
Go ahead, make your motion, Mr.
I'd like to make
McDermott.
a motion to approve V-03-22.
Okay, it's been moved by Mr. McDermott and seconded by Ms. Medina. Roll call.
Excuse me, Madam Chair.
With,
My apologies, ma'am.
yes, conditions.
We have two conditions.
I saw,
Thank you, ma'am.
yes, with the conditions.
With the conditions, yes.
Okay.
Can you state the condition?
Will,
Okay.
was it Mr. McDermott who made the motion?
Yes.
Mr. McDermott
Ms.
made
McDermott,
the,
will you take a friendly amendment to your motion, just for the public record, that the conditions are that there are no spike spears or any exposed sharp projections as a part of the fence, and that the applicant obtaining the permit and all necessary licenses prior to the erection of the fence does so?
Yes.
Okay.
thank you, Mr. Shields. Okay. Roll call.
So, sorry, my apologies. Roslyn
It's
Philippe, how do you
okay.
vote? Roslyn, how do you vote?
Yes.
Michael McDermott,
Yes.
Lena Medina, Blythe Pierre Lewis,
Yes.
Kevin Shields,
Yes.
Takesha Williams.
Yes.
Perfect.
What
Okay.
about myself? I'm not here.
Oh, you're missing one person.
Sorry, her name is not on here. What's your name?
Lumana Joseph.
Philomena Joseph. How do you vote?
Yes.
Okay, motion approved with conditions.
Okay, so your case has been approved, all right? Good luck. Okay, maybe a thing we need to do. So he knows. He's very nervous.
Madam Chair,
He needs to add.
I need to be excused. I have to run over to an event, but you guys have quorum, so it won't affect.
Okay. Let them finish. All right. Miss. Okay, we have a board member who needs to leave, so let the record show that Miss William has to leave. Thank you.
Thank you.
And we still have a quorum. Yay! Okay. And if we can give Isaiah a complete list. You got a list, baby? Okay, good. All right. Next, SE-04-22, which is the tattoo parlor, special exception located at 1675 Northeast 123rd Street. So you will go ahead and, no.
Oh, it was the first one. Thank you, Madam Chair.
Okay.
So bear with us. We have new staff. We are ironing out the wrinkles, and it's the first meeting we've had in several months. So, bear with us. We're going to trudge through this as we can. Thank you for your patience, board members and audience, as we move forward. So the item before you is a special exception for a type 2 parlor. Special exception used pursuant to Article 4, Division 2, Section 4202, Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to allow a proposed type 2 parlor at the property located at 1675 Northeast 123rd Street within the C2BW Commercial Office District. Said special exception is to be reviewed under the criteria set forth in Article 3, Division 5, Section 3-504 of the LDRs. So the property is approximately 1,375 square feet, and the applicant is proposing to occupy 1,000 square feet within that existing building. As you know, pursuant to our LDR's Article 4, Chapter Division 4, 202, a special exception is required for this use at this location within the C2BW area. The property is located on Northeast 123rd Street, approximately, as you can see, a little west of Biscayne Boulevard. You have a combination of several type of uses that are taking place there. Have an open parking lot, as you see. That open parking lot would soon become Mount of Biscayne development, which went through a conditional use permit a few months ago. It's going to be about 385 units, mixed use development at that location. And to your south of you have a commercial use element, and to the west and to the east, also commercial and some residential sprinkled within that. So we have within the code, we have several criteria that we look at when we're looking at special exceptions. We look at, is the use listed as a special exception for the district where it's located? Yes, it is. Is there appropriate provision for access for facilities adequate to estimate it for for traffic and public access from sidewalks to ensure safe to avoid any kind of congestions? Yes, it is. Are there adequate parking areas and off-street parking truck loading space, if applicable, for the anticipated number of occupants, employees, patrons, and layouts So as you saw, you have immediately to the north of the property, you have a row of parking spaces that they can utilize. And when this development takes place, they're also going to have more than 40-some parking spaces on the street that they're going to introduce, and you'll have parking within the development that's going to take place there that the applicant will be able to use, and the other patrons and businesses in the area. And is there suitable landscaping or fencing alongside? So this is an existing site. It is as it is. They will not be doing any improvement such as landscaping. They will not add any fencing there. As you know, you're all familiar with the site there on 123rd. It's a well-established commercial site that's been there for many years, and they're just going into one of the existing bays. Is the proposed special exception reasonable in terms of logical efficiency and economic extension for public services and facilities such as water, sewer, and police protection? Like I said, it's an existing site. It's not going to require any more levels of services with the introduction of this use there. And will the proposed special exception constitute an adequate, appropriate use in the area and will not substantially injure or detract from the use of the surrounding properties or from the character of the neighborhood? I would say it's a commercial area, and it's anticipated that this type of use could be there through the special exception. Special exception allows you, the board, to do a review of that type of use, and if you feel that it needs any kind of conditions associated with the use, that you have the liberty to do so to help mitigate any impact you may feel that the use may have in the area. Based on our review, staff has recommended approval of the item, and we have recommended approval with 3 conditions, and those conditions are as follows: that the applicant obtain the appropriate building permits for any redevelopment or renovations to the interior space, that the applicant obtain a certificate of use and a business tax receipt prior to opening the proposed business, and that the applicant comply with all local, state, and federal regulations. Thank you.
Thank you, Mr. Cook. Is the applicant here? Please come forward. Come to the microphone. Hi. Please state your name and address.
My name is Steven Hernandez.
Good afternoon. I might. My name is Jason Fukene. I'm here on behalf of Carlos to speak to you guys.
And address?
Say it again?
Address. And address.
¿Cuál es la dirección?
Address of the business is fine.
¿Cuál es la dirección? Is 1675 Northeast 133rd Street, North Miami. Okay. Yes.
Thank you. Do you want to add anything to what Mr. Cook said?
Thank you so much for everything. Thank you guys for your time. Yes, I would like to add that this is a dream for us that we've been working extremely hard on. As residents of North Miami, this is an ideal place for us to have our business. So we are well aware of the what we have to do prior to opening our business, and we're very happy for you guys to give us your time. Okay. So, thank you so much.
Thank you. Mr. Hurd, go ahead.
So I just want to share with the board that at least since 2015, federal courts in this area have recognized that tattoo parlors have First Amendment protection, and it requires a significant governmental interest in order to interfere with their establishing a use. So we can go through the test if it becomes an issue, but just to let you know that there is significant First Amendment protection for artistic expression for tattoo parlors. This is a case arising out of Key West and decided by the US 11th Circuit.
Thank you. All right. I will open public hearing. Anyone in the public who would like to speak for or against this item? Okay, I'll close public hearing. Thank you. And board discussion? None?
I'll move to approve.
Oh, thank you, Mr. McDermott. Mr. McDermott has moved to approve with,
The stipulations as set forth by staff.
thank you.
I second that motion.
Thank you, Mr. Shields. Moved by Mr. McDermott and seconded by Mr. Shields. Roll call, please.
Rosalind Philippe, how do you vote?
Yes.
Alina Medina? Yes. Black Pierre Lewis?
Yes.
Lumana Joseph?
Yes.
Okay, item approved for conditions.
You're missing Mr. Shields.
Oh, Evan Shields, my apologies, Evan Shields?
And
Yes.
don't forget-
Okay, item approved with conditions.
Yeah.
Thank you,
All
everyone.
right. All right. Moving right along. Next item, V-04-22. Variance to the minimum distance separation, 631 Northeast 125th Street.
Thank you, Madam Chair. As stated, this is a variance to the minimum distance separation, a variance to Article 5, Division 22, Section 5-2203B of the Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to allow a beauty salon within 1,500 feet of an identical or similar use at the property located at 631 Northeast 125th Street, within the C3 Commercial District. Said variances are to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. So the item we have before you, in a nutshell, is that the applicant is seeking, and where am I?
That's a beauty parlor.
Where am I? That's it. Okay. All right, so the item before you is the variance for distance separation. So to give you some context, which some of you already know, we have within this application within the C3 zoning district. And it was introduced some years ago with the intent to have a minimum separation for certain uses within the city in the downtown area. Beauty parlors, tax collection,
Barbershop.
barbershops, convenience stores, things to that effect. So we wouldn't have a proliferation of those type of uses in the downtown area. And we have, in this instance, the applicant had went through and established a lease agreement and has went in to start the business. And when they came in for the certificate of use, I would believe it's usually what happens. We tagged them saying, no, you cannot move forward with this because we have a distance separation within the downtown area and you are within 1,500 feet of an existing beauty salon in the area, which we have plenty of them in the area. Specifically, in this instance, I believe the applicant is like 431 feet from the closest beauty salon in the area. So that is the nutshell of the application. So when we go through the provisions of the code on whether we can give a positive recommendation or not, as you know, we have 6 criteria as it relates to a variance within the code. And for staff to be able to administer a positive recommendation, they would need to meet 4 of the 6 criteria. So when you deal with that perspective, variance is a high criteria to meet. as it is, as universal within the United States, it has to be a hardship of not your own doing as the foundation of a means to give you a variance recommendation that is positive. To give you an example, if I may, let's say if you had a land that you owned and we had a flood. And when the flood came through, it took part of your land. And you wanted to build on it, and now you can't meet certain setbacks because that was taken away from the flood. That's a criteria to give you a variance. That's a hardship that was created not of your own doing. So that's the threshold that we have as staff that we have to look at along with these 6 criteria. And when we did our review, she only met tentatively 2, the applicant only met 2 of the 6 criteria. So we were not able to render a positive recommendation to them. If you wish, I can go over the criteria that we look at, and if you wish, and we can go.
Mr. Cook, would you mind going over the criteria if you don't mind?
Mr. Shields, sure. Thank you, sir. So the criteria that we have is the first one: special conditions and circumstances exist which are particular to the land, structure, or building involved and which are not applicable to other land, structure, or buildings in the same zoning district. No. Yeah, so you don't. The second one is the unusual circumstances or conditions necessitating the various requests are present in the neighborhood and are not unique to the property. No. So we put yes there. So it's the criteria. Let's see. So it's how you ever look at it in this set. Okay, you have 14 existing beauty salons in the area, and you have a 1,500-foot separation requirement. And the closest one, as I said, is 415 feet away. So,
1,100.
and then you have one at 366 feet, and you have one at 393 feet. So, there you go. That's a circumstance in the area that I guess you can call unique in that aspect, that, the applicant, we just have it, and you came in and said, okay, it's hard if you want to look at it. You can meet that 1,500 feet because you already have those uses downtown, and that's a unique situation. But that counter goes against what was the purpose of the code and the regulation being instituted by the council some years ago. But it is what it is, and it's up for you to assess that as a provision of the criteria for a deviation for the requirement. The second one is that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the neighborhood. You say no, and you say no in this aspect, and I'm gonna give you a counter perspective so you can think about it also. No in this aspect because you have a specific regulation that was instituted with the intent not to create a proliferation of these type of uses and a saturation of these type of uses in the area. The other criteria you can look at is that it's a commercial use and the downtown area is intended for commercial use. So that's a thought, but it does not meet that criteria. The literal interpretation of the provisions of the LDRs would deprive the applicant of the right commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. We say no here, that the literal interpretation of this provision does not deprive the applicant of the right of commonly enjoyed in it. And you would say no, why? You have other commercial uses that you can use and do in that area. It just have, in this instance, they're seeking to do a beauty salon, and we just have this separation criteria there. So it really doesn't prevent them in literal interpretation from doing a business there, just this specific business, because the separation is not met, and thus why they are here today requesting lenience on that requirement. The variance request is a minimum variance that will make possible for the reasonable use of the land and structure of the building. So we say yes here. That's generally what we say yes. The applicant needs this variance to do what they desire to do. The granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. So we say no here, and that was just specifically based on the criteria. You know, you could make an argument that maybe it wouldn't. You know, it's just to your thinking and how you think about it. Do we want certain uses to saturate our downtown area, or do we desire to have a multitude of different uses that are in our downtown area that brings about a destination spot for our downtown? Or do we want all tax collections? Do we want all convenience stores, barbershop, hair salons, things to that effect in the downtown area? So to us, it doesn't meet that criteria because the intent is not to allow for the saturation of that. So with that, we had a 4-2, 4 that they didn't meet, 2 that we felt that the applicant did meet as it relates to this criteria. And that we have recommended the denial of the item. However, if the board deems an action of an approval, consider the following condition with the approval: that prior to the commencement of the business operation, that the applicant must obtain all necessary licenses and permits, and such as the building permit, certificate of use, business tax receipt, etc., and must comply with each applicable LDR's requirement and city, county, and state and federal regulations. Thank you.
Thank you, Mr. Cook. Is the applicant here? Okay, come to the microphone. State name and address, please.
Good afternoon. My name is Joanne Bido. Address is 631 Northeast 125th Street.
Okay. Anything would you like to add to what Mr. Cook said?
I can say my English is not so high. I speak in Creole or Spanish, but I can explain a little bit in Creole. Mr. Asia can help me, and in this case, c'est un plaisir aujourd'hui à nous capable rencontrer nous. Merci beaucoup d'avoir que nous venus.
My translation. Sorry, my Creole is not that good.
I'm going to put you
All right, thank
on
you.
punishment. Okay.
Yeah.
It's a pleasure for her to be here tonight. Okay.
Thank you for us. Yeah. My question, suggestion par moi, m'pat dans position pour me venir affronter personne. Dans ce sens ça, c'est d'avoir que moi j'ai un monde qui a contact avec maître local là. Il te gagné un beauty salon déjà depuis 17 ans.
Okay, let me translate. Not too fast. Okay, it wasn't her intention to be in confrontation with any rules and regulation. The recommendation was given to her to meet with the owner of the place who had a beauty salon for several years at that location. That's what I understood. Okay.
The name was the name was Garden Beauty Salon. Okay, and les que dame nan li référé moi, li pas capable payer rent là, et puis li passe m liste là. Moi payer liste deposit tout ça 3 months, and pour moi même, je pense que l'état possible.
Okay. So the previous owner of the beauty salon apparently got into financial bind, so passed the business over to her. She took on the lease. She's paid for 3 months, so she believed that this would be possible. So I guess.
Les que me fait liste là, yo retiré association moi dans corporation moi dans Sunbiz.
Sunbiz.
OK, yo mettez dans application pour moi même everything tout bagay t'a OK. c'est après les que moi commencé à ranger en dedans parce que en dedans gen plombine ni toute bagaille, c'est seulement floor que me fait avec peinture et puis les que mal sollicité li, les presque fini et puis moi je une nouvelle là nommée Azir.
Okay, so she thought everything was fine, so therefore they took her information from Sunbiz, they included it in the application. The only thing that she did was floor and painting because everything remained the same. And that's when she came to apply to us here in North Miami, that's when she found out that there is an issue with her going in. Okay.
Alors, m'a dit non, I'm sorry pour moi et I'm sorry tout d'abord que jodi nous réunir sous cas moyen. Et nous avons souhaité que nous considérions ça pour moi parce que moi investi tout ça que nous avons gagné dedans. Si nous l'avons gagné, c'est comme si seul espoir, c'est nous-mêmes.
Okay, so basically I think you guys understood that she spent all of what she had. She spent quite a bit in doing what she had to do to prepare herself to start this business. So now she's depending on the board to give her a favorable outcome so she may continue. Mr. Cook?
So, if I may, through the chair, my apologies. So, this is a difficult situation, as you can see. As a norm, based on her context of what transpired, if she would have immediately moved in, let's say if right after that gentleman he hadn't had a lapse in his certificate of use, she came right in, she would have been no issue. I would presume, based on what I understand, that she came in, the previous operation of a salon had probably been there, but it wasn't any certificate of use. 180 days had elapsed, and once that, all rights that were there are gone. And she wouldn't know that. She would assume logically, oh, it was previously a salon, wouldn't know, except you investigated that it was a distance separation requirement, and coming in, logically you would think I can just move on in because it was a salon there, or has been a salon there, based on her perspective, and so she made the investment to, under good faith, that you can do so. So here we are.
Yes, Mr. Hurd.
Mr. Cook, actually, the case law on abandonment of use doesn't look only to time, it looks to intent. And if there's an intent to continue the use, then the time lapse is not a strict cutoff. At least in this part, they did not remove all the existing fixtures, and there might have been an intent to continue the use. I don't know what the timing was, and the other question, I actually had a question as to whether the existing salon was part of the 14 or so that staff identified as being within this radius.
It's a good question.
So that's important, because Mr. Hill is the attorney that's quite intent. We have had case and situation as diminutive as somebody keeping up a sign was grounds to continue the use, even though it has been 180 days since the actual use was taking place there. So, and forgive me on my level, ignorance for full disclosure, these things were not discussed. I don't know if they had still that, Mr. Hill brings up a valid point. If you still had salon equipment in there, such as the chairs and certain other elements, and then she just did, then that could be grounds, as he said, to do it. I don't know if that was the case. The applicant would have to speak to that. When it comes into our house, when we look at it, we're looking at it, hey, was it a salon there? Was it another use that may have taken place between that salon and that, which may have taken place?
Well, based on what she said she only did floors and painting. So all the equipments were there. So at least that part.
Yeah, I have a couple of other points.
Yes, Mr.
One
Hill.
is, and Mr. Cook and I were talking about the application earlier, and I sort of made a joke, but it is relevant. There's a lot of beautiful people in North Miami that need the service of beauty salons. But another point is that the way the code is structured, this board does have the discretion to grant the variance. If the council did not want the board to have this discretion, they would have made it, they would have excluded this from the list of permitted variances. So the board still could grant approval. Now, if Ms. Warren was here, I feel obligated to tell you that she would say, we would have to go through the criteria to make sure that the answer to 4 of the criteria are answered yes. So we would just, if the board is interested in exploring granting approval, we could take a few minutes and look at the criteria to see whether the board would respond favorably to at least 2 more of those, because there are 2 that were, at least per the record, indicated yes for staff.
Okay. All right. Thank you. I'll open public hearing. Anyone for or against? Public hearing is closed. Board discussion.
Yeah,
I have a question.
I have a basic philosophical point on this. You know, and I was on a committee that set up a lot of these ordinances and codes and that kind of thing. And we have a real problem here in she's impinging on the businesses of 2 other businesses that are in close proximity to her, which he put out. At the same time, there was obviously a business there to begin with. So it's like, you know, and it goes back to the problem is that we pass out too many variances on a lot of different issues of people just want to do their own thing and think they can just, you know, well, that's what I want to do, and to heck with this code, I'll get somebody to waive it. We have these established codes for obvious reasons. I mean, nobody said, gee whiz, we'll just pick 1,500 feet out of the air somewhere to create a separation between like businesses. I mean, obviously, if she's within 300 feet of another beauty salon and 400 feet, that's pretty close. So, you know, basically you're saying, well, listen, you just can't automatically impinge on somebody's business because you happen to want to open up a beauty salon. I mean, the question is, are there no longer any rules to the game? Or are we just going to nip away at variances until there's no codes left? So, but on the other hand, out of fairness, somebody was there before her. So how in the heck did that person get there when they were in violation of the code? And it's probably because somebody gave them a variance
They might
somewhere
have
down the
been
line.
the original 14. We don't know that.
Right,
Well,
Mr. Chair,
they didn't
Madam
get-
Chair,
they
I
didn't-
don't think you can assume that they were there illegally. I think you can assume that they were there legally because they probably would have received occupational
Well,
licenses.
then
from the
that's
city.
exactly what I'm saying, Gary. They probably came here and got a variance to open up because they're in violation as well of the other 2
Well,
businesses.
once you receive your variance, you're not in violation. You're permitted legal use. And it may be that they were the first in the area and all of the others around them were the ones.
Well,
Remember that-
you're making my point over and over and over again.
I'm trying to make different points because I'm
Okay.
disagreeing with you.
I know Ms. Joseph has something to say, but I just want a quick response to Mr. McDermott. We have to remember that that code that was put in for the distance didn't happen a long time ago. It was just a few years ago. And I think at that time, council was looking to see how should I say, get different type of businesses into the downtown district. Not so much that you're impinging upon someone else.
No,
Because
they didn't want the proliferation of like businesses for two reasons. Number one, because it doesn't create a downtown that's viable. And number two, it's like, anything else. You're going to whenever you create competition, you're going to take money out of the pocket of somebody else you're moving next door to. So I think there were multiple reasons, that they did that.
Well, I think council at that time might not have been very, open-minded in looking at looking at like-minded businesses, because a lot of these businesses, they're saying that they don't want too much of. These people come with their own clientele.
Well, the thing is, we weren't the council that created those rules, and obviously they created them for a reason. But, that said, we have a situation here where she's stepping in the shoes of an already existing business.
Okay,
So-
I'll let Ms. Joseph speak, and then,
I just had a question. How would Ms. Vital know that with the variance code of 1,500 feet, how do one person know when they're opening a business or a shop in the city? Where would they go and find this information to know if there's an existing business here, I have to be 1,500 feet away from them before I rent the property?
So, this is the, forgive me, for lack of a way to characterize it, we expect a level of due diligence by the property owners and the leasee to investigate whether they can even do as something as remedial. Can I do this use here at this location? And to talk to the, we do have to, and we do make efforts to let property owners know, and I would think mass majority of the property owners know that we have these distance separation restrictions in the downtown area. So that's the answer. Do we have anything to your thinking, I believe, ma'am, and forgive me, that that is blared out there, advertising it, saying that to everybody? If you came to the website and it was clearly up there, like on page 1, no, we don't. It is nestled into the body of the code, and we require you to say, okay, I'm wanting to do this lease agreement at such and such. Let me contact the zoning department to see if I can do this use, and if I can do this use, is there any restrictions associated with this use?
Mr. Held, going back to what you said in terms of the use that was there before and her going in. I know with childcare, there's such a thing as grandfathering in based on the square footage, especially if the person, well, I think the only difference is if you're changing, I guess, ownership, but with the childcare center because it is, a different license. But in terms of that particular location might have been part of the originals who were there, and if she still fits in based on the fact that it's the use, and that's something that we need to consider. And I hear you, Mike.
We do have a staff denial on this.
Yes, we have a staff denial. I remember we had another case that came in front of us, which was a barber shop. We did deny them. I remember that. But this is what I have to say. And that's me being on my soapbox. We have council making wonderful, great things in terms of we don't want so many this, so many that. But I don't see the effort that's being put in to bring those desirable businesses to fill up those empty spaces in the downtown district so that we can have a vibrant downtown. You turn around, this goes in, and then the next thing, a couple of months down the road, they're closed. And we are back to an empty space. And when we're going down our downtown, I drive to North Miami Beach. And let me tell you, when I first moved to Miami, I lived in unincorporated Dade near North Miami Beach. I'm surprised of that strip that's right between 8th Avenue and 10th Avenue. What has gone in there? Okay? I go to 27th Avenue in Miami Gardens. I see all these businesses, you know, you getting nice shops and all that. But we don't even have the space to even bring these type of businesses here. And then we keep giving people who want to make sure they go in and at least show that there is some business going on in our downtown an issue. I voted against that barbershop when this thing first came in, but at this point, I don't know where I stand. Because I keep looking at empty stores between 6th Avenue and 12th Avenue. On West Dixie, it's the same thing. So what are we gonna do? All right, I'm sorry. I got off my soapbox now. Any more board discussion? Do we have a motion?
I think one of the issues that I see both your point and Mike's point too. I think looking at one of the denials by staff here is that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the neighborhood. The issue that we have here is, even though we could argue the philosophy of this, there's still how many businesses of a similar nature within a 1,500 square foot radius? I think I read 14. Is that correct?
That's correct.
So this would add number 15? What's the difference?
Or number 14?
Or,
Because if it was one of the original 14, it'd still say 14.
but also I read, if I'm not mistaken, that the prior use of this immediate space was a tattoo parlor. That's what I read on page. I'll pull it up in a second. I could be wrong, but
So, is that a question, board member?
that actually is a question. It's on page 75. It says that throughout the years the building's been occupied with various retail and service uses. The previous occupants of this unit was a tattoo parlor.
So, with my consultation with staff, that was an observation based on signage that was there.
Okay.
Okay.
And I don't know if they had a certificate of use that would, I find it hard, I don't know, because I don't recall, I go past that location, and as you had tonight, a tattoo parlor requires a special exception.
Mm-hmm.
So I don't recall that going through a special exception there.
Okay.
But who knows? Okay, I've said too much. Back to.
Understood. So, to the point of this, I think this is philosophical, but in many ways, the answer of that question could be yes. But then the other issue that we have here is we would need at least one more regulation that we would need to flip from no to yes in order to get to the 4 of 6 that staff recommends. I see both of your sides of this. At this point, I lean to our chairwoman's side, mainly by nature of there's already 14 other existing businesses of this exact use within this area. I would love to see more diversity of businesses in our downtown, but that's beyond the powers necessarily of this board. This board has to kind of call it as we see it based off of, unfortunately, sometimes based off of the actual reality of what's happening in this part of town. And that's the actuality that we face.
Well, then the other side of that coin, Mr. Shields, is if you already have 14, some of which are probably in violation of the code, why would you want to add a 15th?
Yeah, but Mike, why do you keep assuming that they're in violation? We don't know when these beauty parlor was there. As a matter of fact, I know on West Dixie, there is a beauty parlor right there, right by Kayar. They've been there 15 years minimum. They're counted in. So why are we assuming they're in violation?
Well, here's the thing. We have staff who says they only meet 2 of the 6 criteria, and they've recommended denial. So I don't know. I just...
The issue that I see is that I could maybe flip on that third that I just mentioned, but I can't find the fourth. That's another issue. I would maybe
I'm happy
recommend,
to help.
I would ask for any other
Okay, the
recommendations.
attorney's right there.
So, Madam Chair, in my opinion, you could take one of the others and reach an equally opposite opinion based upon point of view. So, if, for example, the last one, granting of the variance will be in harmony with the general intent and purpose of these LDRs, which would be without respect to the distance separation. You're bringing a business to the area and allowing for thriving downtown regardless of the nature of the business, and the variance will not be injurious to the area involved. Along the theory that there's already 14, one more will not seriously harm the area, and at more than 300 feet, this is not more than one per block anyway. So it's not like you're driving along and you see 3 in a row. The nearest one is at least a block away. So I think in addition to the one that you identified, I would answer the last one yes.
Okay.
So that would give 4 yeses, which would allow the board to grant approval. Make a motion.
Okay. So I think to that point, the basic question comes down to, are we okay with 15 of this existing business being in this area?
It may still be 14.
It may still be 14, that's
Well,
true.
Yep, it may still be. I would move for approval based off of the opinion of this board that we could change the interpretation of those 2 exact points from no to yes, which would bring this to a 4 out of 6 opinion,
Along with staff condition.
along with staff conditions.
Okay, so we have a motion to approve, so we need a second.
I second.
Okay, so we have a motion and a second. Any other discussion? All right, roll call.
Chairwoman Philippe, how do you vote?
I vote yes.
Okay. Board Member McDermott?
Yes.
Okay. Board Member Medina? Yes. Board Member Pierre-Louis?
Yes.
Board Member Shields?
Yes.
And Board Member Joseph?
Yes.
Wow.
Item approval.
Congratulations.
And to follow up on that has nothing to do with the case. Again, these are the issues that comes before us. What are we doing to educate the folks who want to bring their businesses, but they're not owners of these properties, and the owners wants to make the money, so they're not gonna tell them, and they're not telling them.
And she's
And they
right.
have people investing their money,
Yes.
and, they run the risk of losing it all. Didn't we have an issue like that with the barbershop was one, and a couple of childcare centers? What are we gonna do?
Further, if I could
I'm
add
looking at Mr. Cook, I'm sorry, it's not your fault, but
if I could just add a general comment, I think the nature of this board as a quasi-judicial board is to decide on policy and whether or not it meets with what's in our code and what is in our ordinances. I'll also say to Mr. McDermott's point, and to your point as well, Madam Chair, we need a general vision for what needs to be in downtown. And that is not necessarily the spirit of this board necessarily. That goes beyond our authority. That doesn't mean that we can't necessarily make our opinions on that, but it's beyond the spirit of what we can do.
I'm a bit discouraged because we go way, way back. I think Mike will be able to tell you more than I can because he was probably more involved with the charrette. It started way back then, but we're still here. And I see cities all around me doing something. Again, it's vision. But we also don't have the ability that they do we don't have the land, you know, because everybody's going big, you know. We talk about multi-use. It would be great for 125th, but when is it coming? I think everybody, well, shut up, Rosalind, no.
My only point to your point is that we need a general vision, and we need it now. And that's not necessarily the point of
Right.
this exact policy that was brought up to us to vote upon, but, you know, it's just something for the record, and that we voted for this, and, you know, we appreciate having the business here, but we certainly need to also think bigger, and that's not necessarily just a question for us. I think that goes beyond us, but I want to make sure that it's known, because I think that's the general spirit of this board and what was discussed here. And that's it.
Okay,
All right.
Congratulations.
thank you. Next item.
Okay.
Yes, Madam Chair.
Yes.
Next item.
No, we're done with this.
Yes.
I move on. Next thing, V dash 05-22, which is fence height and opacity variance within front yard, located at 13485 Northeast 2nd Avenue. And I know that area.
Thank you, Madam Chair. As stated, this is a fence height and opacity variance within the front yard at 13485 Northeast 2nd Avenue. A variance to the Article 5, Division 12, Section 5-1210, A1 and 3 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to allow 100% opaque fence in the front yard setback and to allow a 6-foot tall fence within the required front yard at the property located at 13485 Northeast 2nd Avenue within the R2 Single Family Residential District. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the Land Development Regulations. So in a nutshell, what we have here is, if you recall earlier when we was talking about the fence in the R4 district, you have two criteria for fences within the R1 and R2 district that would allow for you to have your fence within the front setback area, which is from the front property line 25 feet back. And that criteria is that your fence cannot be higher than 5 feet, and it must have no greater opacity than 25%. In this circumstance, the applicant has a fence that is 6 feet tall and is totally opaque. Now, how this came about is that when they came through the building permitting process some years ago, it was approved based on the criteria that are specific to the R1 and R2. However, when the applicant installed the fence, it was installed with that 6 foot and completely opaque. Then subsequent to that, when it was reviewed by inspection, the inspector approved it. And when they did, went out and did some edits, they noticed that this was approved in error, and here we are. A variance is needed if they wish to maintain this fence as it is, and have brought this before you this evening to allow for a deviation in the code. And one of the mitigating factors that they have introduced to help with the safety issue, that they have put up, you know, those little owl mirrors that you have on top that allow for you to see your traffic to your left or to your right, to help mitigate when they're doing the ingress and egress out of the property, so they can see who may be coming. And that was one of the criteria that we had put forward. So with us, we did our review. We saw they could meet 3 out of the 4. You know, you have an error by the city in inspection, and what other elements that you have in those 3 that we had there. Let me go into them if I may. We said yes, there's a special condition associated with this. You know, you had the approval and error. You know, it's a There's a mindset in that when you have already established, you have installed, you made an investment, and you've been operating in that aspect for many years, that it becomes burdensome to have them to change it when the error, even though the error is by the city. And the city doesn't have any obligations to perpetuate the error. It is within our jurisdiction to say, no, you need to correct it. But in this instance, the correction, without them being burdened any further, is to have them go through the variance process to deviate from the criteria that are set forth in the code on the matter. The second one we had, it says that the requested variance maintains the basic intent and purpose of the subject regulations and stability. Basic intent, that is that we permit you to have a fence to enclose your property. Yes, it doesn't meet the other criteria such as opaquity and height, but it does meet the basic intent that we intend for single-family residential homes to be able to have a fence at their property line. And the third one that we thought is the variance request is the minimum variance necessary to allow for them to maintain what they have, and that is true as it is. And based on that, staff didn't make any recommendation. This would just be to allow them to maintain that fence. They already have the building permit for the matter, and here we are. We have the building official here, the building directors here to speak, if so needed, on behalf of the applicant. And let me give you some
Mr.
pictures.
Cook, can you put up the picture of the fence and what it looks like right now?
The-
Do you have,
Yes, yeah, I'm going through it. Let me see if they bring it up. Can you see? It's not there. Let's see. Let's see. Okay, here we go.
okay.
Yeah.
Right there.
So it is. You can see it, the white.
So they do have what I call the iron picket part that sort of like slides.
Yes, as the
Okay,
gate.
and it's that piece to the side.
Mm-hmm.
Okay. Mm. Looks like it's falling apart already. Oh, no, that's their neighbors. Okay. Thank you, Mr. Cook. Is the applicant here?
Good evening, everyone.
Good evening. Please
My
state
is
your name and
Merveille
address.
Souffrant. Merveille Souffrant, address 13485 Northeast 2nd Avenue.
Thank you. Anything you would like to add to your case?
Well, my case is unique, and as the board member already know, the fence was installed back in 2014, and I was not aware that was not based on code and compliance until after I applied for another addition to my house, which was finished back in December 2021. And when I applied for my CO certificate, that's when they say, well, you need to remove that fence. And it was shock to me. I never knew that I had a violation, because if I had a violation, they would not allow me to apply for such a big permit for 1,700 square feet addition. Then when I discussed with them, I said it was apply and approve. Then when I actually present them my paper, the card that was signed by a well-experienced inspector, then that's when that become a discussion. They say, okay, we need to go before the board member to see what they can do for me. And I would appreciate that board member consider to allow me to keep that fence, which in my opinion, with the mirror, we will be doing great, because already we were doing great. It was never an issue. It's not compliance officer that come to my house saying you're in violation. It's someone in specific that brought that to the city attention saying she's in violation. Just because of little reason that I'm not going to detail, that was a Merveille, you doing bad. And I wasn't doing bad. It was just little concern as resident we had, and I just brought them forth, and I was thanked for that. And I would appreciate if you guys consider to help me, because for me, it's not something I can address right now.
So you were the owner in 2014 when the fence was put in?
Actually, I purchased the house in 2013. I was the one applying and still pay for installation of the fence.
Okay, and a company did this?
Yes,
And they submitted what type of fence that you would be putting in?
yes, Madam Chair.
Okay,
Everything was completed and signed for.
all right, thank you.
Thank you.
All right, open public hearing. Anyone for or against? Speak now or forever hold your peace. Board discussion, close public hearing. Board discussion?
He wants
Oh.
to speak. Gentleman in the back.
Public hearing? You would like to speak? Okay. Good
I'm the
evening.
building director. So I kind of reopened this fence permit based on the safety. And so I guess I'm at fault for Ms.
Could you
Merville's
speak, could you
hardship.
speak into the microphone?
The
Oh,
mic.
sorry.
There
My
you
name
go.
is Mayor Jean. I'm the building director. So I'm kind of at fault for reopening this case and giving Ms. Merville this hardship. I felt that this was a safety concern as she, with the gate being opaque or obscured, that even someone on a bike or pedestrian walking as the car backs out, she would be unable to see anyone, oncoming pedestrian, in the way of, if she were to back up. So I'm recommending that a parabolic mirror be placed on the side where she can view any oncoming pedestrian for the property. So this is a concern that I had, that I kind of reopened that fence permit in order to address the safety issue.
And based on the picture that we saw, it's not her entire fence that's opaque. It's really the side piece. So how much is on that side if she were to, let's say, just, I'm thinking of what all the others that I've seen, what they do, those type of fence, they stay to a certain position, and then the iron bars are the ones that they come all the way out to outside to the property line.
I mean, normally in the front, and Derek, help me if I'm saying something wrong. Normally in the front yard, it should be a fence that's 5 foot tall, but you can see through it. So even if someone's walking, you can basically, turn to the other side and see any oncoming pedestrian. But in this case, since the fence is 6 foot and it's unable to see through the fence, your visibility is limited until your car's halfway on the sidewalk to come out. So that's kind of the issue, the safety issue that I see with the fence.
Okay, I got you.
Okay.
Thank you. All right, we'll close public hearing.
Okay.
Board discussion? Ms. Medina? Is it on?
Yeah, turn on the.
Turn on the mic, yeah.
Thank you. So my understanding is that you would like to build a 6-foot fence in front, completely opaque?
No,
No, it's
The-
already
Leave it as
there.
is.
it's
On the
called
side.
the front yard, but that's only because it's in front of the house.
Yeah.
This particular fence is on the side property line.
Okay,
So the front fence, which is the picket fence you can see through,
Yeah.
will stay the same.
Okay.
So nothing is proposed to be changed, just the only change would be adding the parabolic mirror
Okay.
to resolve the safety issue that the building director said. And if you look to
Like this one.
the building department's memorandum, they are actually recommending approval. Recommendation to the Board of Adjustment will be that the fence stays as is, but the parabolic mirror be added to help with the life safety issue.
okay. Thank you.
Chair?
Mr. McDermott, go ahead.
Yeah, I'll go ahead and make a motion to approve, together with the requirement of the building department.
Okay, so it's been approved, it's been motion to approve by Mr. McDermott with the proposed requirement for safety, which is at the addition of the mirrors and anything else.
I second that.
Seconded by Ms. Blythe. Okay, it's been moved and second. Roll call, please. Thank you.
Chairwoman Philippe, how do you vote?
Yes.
Board Member McDermott?
Yes.
Board Member Medina?
Yes.
Board Member Pierre Lewis?
Yes.
Board Member Shields?
Yes.
And Board Member Joseph?
Yes.
Item approved with conditions.
Thank you. Okay, so your item has been approved. Just verify in future, please. Check twice, check 3 times. All right, next item. V-06-22, which is a recreational vehicle parking in the R4 Residential Zoning District, 1400 Northeast 133rd Road.
Thank you, Madam Chair. As stated, this is a recreational vehicle parking in the R4 Residential Zone District at 1400 Northeast 133rd Road. It's a variance to the Article of Division 14, Section 5-1405 of Chapter 29 of the City of North Miami Code of Ordinances, the Land Development Regulations, to allow the parking and/or storage of a recreational vehicle located at 1400 Northeast 133rd Road within the R4 multifamily residential district. Said variance is to be reviewed under the criteria set forth in Article 3, Section 6, Division 6, Section 3-606 of the LDRs. So, the circumstance here is that we have a single-family home that wants to park their RV. They were in R1 or R2, they would be allowed to park that through the administrative variance process, which we just come in through our office at Community Planning and Development. We'll do a review, make sure that it's, you have the park, proper screening, if it's visible from the street or something like that, that it's in the back, that it's on concrete, or because it can't be parked on grass or some kind of paved material. And we'll notify the resident to the left, right, across the street, and behind if they are not, it's not a canal or something like that. And 30 days, we're done, if we haven't heard any objection. The fact that the property is located in the R4 is similar in some instances to the fence situation that we heard earlier today, this evening, that they want to operate their property as you would a single-family resident within a single-family home district. And in this instance, to be able to do as such will require a Board of Adjustment variance to allow for them to park their RV at their parking, at their residence. And with that in mind, that's why we're here. We have recommended that they do so, and that what we would say that they would need to do is that if it's not parked on any kind of concrete, pavers, or some kind of solid material, that they need to do so, and make sure that it is not visible from, not in the front yard, it's in the rear yard as they plan to do, and things to that effect. And they should be okay in this instance if they meet those criteria. But it's to your discretion if you feel necessary to allow them to be able to park their RV as such. If you do not, then they would need to find somewhere else to park it.
I just had one question. I don't think it was clear for me.
Sure.
It's towards the back. Is there like an alley where they're at?
So,
Logistically, how do they get it in there? That's my question.
so they would have to come through the side yard to get there? So let
Oh,
me see.
okay.
What picture are we looking at? What's this? Oh, boy. This is this. Your picture's not here.
No, that's the wrong,
There you go.
that one.
That's the front
There
yard.
it is.
So you go. Okay.
Okay. All right, thank you. All right, is the applicant, I'm sure the applicant is here. State name and address, please.
My name is Danny Wings. My cousin Bellato, I represent for him, for her. Is the address is 1400 Northeast 133rd Road, North Miami. And Bella, she likes outdoor recreation. That's why she bought the RV, and she have a lot of nephew and cousin. So they are little, so they like to hang out with her, and when she go to the camping or go to outdoor activity. So we bought that vehicle, and we didn't realize that we need to have the parking permit, and we don't know anything about it until now. But the vehicle is parking on the concrete, and we enter from the front to the back, and it's parking all the way to the back of the backyard. In the backyard, we have the alley also, so we can get in and out both ways.
All right, thank you.
All right, thank you.
I'll open public hearing. Anyone for or against? Come on, state your name and address.
Yeah, hi, good evening. My name is Walter Suarez. I live at 1430 Northeast 132nd Road. My mom is the homeowner. We both live there. We've lived in North Miami for over 30 years. My concern with this RV is that the RV is there. However, this RV is the size of a small apartment. I don't know exact dimensions, but it is very large, and it is visible from 14th Avenue. There are no trees or anything covering it. I personally don't have any issue with the RV being there. My issue is that it would be used as a temporary or a permanent residence. I've noticed lights on when I walk my dog at night. It's been there probably over a month. And that's my only concern. And if this were to be approved, would it set a precedent throughout our neighborhood? Would my mom and I be able to put something like that and rent it out to somebody who needs a dwelling? That is my concern. Thank you.
And which I don't think our code does. Okay. Mr. Held.
Well, Madam Chair, you can easily add a condition to approval that it cannot be used as a temporary permanent residence. That would only be occupied, I'd say, overnight away from the property. Except in the instance of a hurricane or damage to the main residence, I suppose, something like that.
If I may, Madam Chair, if I may expand on Mr. Hill's thing. Within our approval, it is indicated that you cannot utilize the RV as a residence. It cannot be hooked up to electrical or any sewer system whatsoever. It's just to be parked. If you look within the contacts of your package, there are some pictures of the RV and the rear yard. We don't have a criteria on necessarily the size of the RV. So.
Okay, thank you. All right, public hearing is closed. Board discussion.
I have a question for Mr. Flores. If it is approved with let's say before be approved with the premise that it cannot be occupied like a residence, Would that be something that will work for you?
For me?
Yes.
Yes, I have no issue with the RV being there. My concern is that it would be used as any kind of temporary or permanent residence.
Uh-huh.
And the precedent is such.
I have a question for the applicant. What is the RV being used for? And apologies if this was already stated in the presentation.
You have to use the microphone.
It's used for recreations. So it just park there. We don't use for living or do anything. We don't store anything inside. Anytime we need to use to go somewhere, we just hook it out, take it out, and go somewhere and use it.
Okay, so you travel with it and use it?
Travel, yes.
Okay, okay. And is there ease of you being able to, I know you said it, but I just want to reiterate, is there ease of you being able to pull it in and out of
Yes.
the space in which you're storing
Yes.
it?
You can get in and out easy.
Okay. Thank you.
And Mr. Cook, because he's in R4, if he were in R1 and R2, it would be a simple permit just to park his RV. Because I've seen them all, on the side of the house,
So if they were R1 and R2, they would require an administrative variance to do so. And the criteria that we have, you can have it at the side or the rear, you can't park it in the front of the property. And it would need to be on paved surface, concrete, it could be pavers, something to that effect.
Okay. All right. Any other board discussion? Would someone like to make a motion?
I'll go ahead and make a motion with the condition that it not be utilized under any circumstance as a residential, temporary, or permanent.
Thank you, Mr. McDermott. Do I have a second?
Is that sufficient, Gary?
Well, I was concerned about the hurricane exception, or that there may be an emergency, except for emergency use. After hurricane.
Okay.
You can, we can be as precise as you want.
Okay.
Are we talking about it, Mr. Hill, if they are not able to occupy their home or and then they could?
Yeah.
Is that the same thing you do in administrative variance?
We don't put that criteria in. We just say you just can't, you just can't utilize it as such.
They should, but I recommend that here.
Okay.
Ms. Joseph, did you have a second?
Yeah, I second, with the exception, the conditions.
Okay. It's been moved by Mr. McDermott and seconded by Ms. Joseph. Roll call, please.
Chairwoman Philippe, how do you vote?
Yes.
Board Member McDermott?
Yes.
Board Member Medina?
Yes.
Board Member Pierre-Louis?
Yes.
Board Member Shields?
Yes.
And Board Member Joseph?
Yes.
Okay, item approved with conditions.
Thank you. And our last item, I think, V-07-22, a variance to permit a reduced setback for a driveway, 830 Northwest 121st Street.
Thank you, Madam Chair. As stated, this is a variance to permit a reduction in the setback for a driveway at 830 Northwest 121st Street, a variance to Article 4, Division 2, Section 4-203 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to allow a reduction from the required side setback of 7.5 feet to the proposed setback of 1 feet. And the correction there, that was how it was advertised, but the correct terms should be that it is a setback of 5 feet. And the request is for 1 feet. What it is that our code requires that impervious or concrete surfaces be a minimum of 5 feet from your side setback or your rear setback. And if you can, through the administrative variance, you can deviate from that if you have pervious material up to 2.5 feet. In this instance, the applicant has 0 has 1 foot, and it is impervious material that they have there as their driveway. And that is the very essence of their request, to allow for that deviation of 4 feet really, and to be impervious materials. If you see, you have the property that is located there, surrounded in the middle of the neighborhood, and there you are. When we did our review for the application, as you know, you have 6 criteria that we look at, and you need to have 4 of the 6 to obtain a positive recommendation from staff. The staff did their review. We were able to come up with
I believe it's 5 of the 6.
5 of the 6. Let me see. There we go. So we have a special conditions and circumstances exist which are particular to it. Yes, it is noted that the existing non-conforming driveway aligns with the carport and stuff. So what we have is an existing carport, and when they went to install the driveway, to be able to align that driveway so they can drive into their carport, it needed to be at a certain distance of 1 foot from the property line. To be any different, then they would be driving on the grass, which you're not allowed to even park on grass and things like that. So they're expanding the driveway so it can be aligned with their carport. You have no for number 2. You have less for number 3 is the requested variance maintain the basic intent of the subject regulations particular to effective stability. You say the basic intent is that to allow people to have a driveway. Where you would have it, we like to have a 5-foot setback. That 5-foot setback allows for drainage when you have rain and things like that, and it helps mitigate your water flowing into other people's property with you, because you have that area where they can drain in into the land. And item number 4, you said is the literal interpretation of the LDRs prevent the common enjoyment. Literal interpretation, if you did that, they wouldn't be able to have the driveway that is functional as it is to allow for them to be able to drive into their carport. It would not prevent them per se to have a driveway, it just would not be in alignment with their carport, and they'd be sitting out there in the thing. And what you will have is, in Candid, you'll have them still driving into their carport, it'll just be driving over grass, and you know what mess comes with you doing that. That's why we don't want people parking on the grass and things like that, because that deteriorates the ground and make it messy. And number 5, we said that the variance request is the minimum that they would need to be able to allow them to maintain the driveway as it is. And this is the granting of this variance. Will it be in harmony with your general intent and purpose when with the LDRs, and the variance will not be injurious or to the area? You know, its perspective, we're saying yes, it would not be injurious to the area by allowing them to have that driveway. You have the deviation that we spoke of, and that's where we are. With that, we are recommending approval. We are recommending approval with 2 conditions: that the applicant obtain a building permit and all necessary licenses prior to any driveway construction or reconfiguration and work, and the applicant obtain approval of the existing conditions from the Public Works Department. So that's as it relates to the apron of the driveway, which goes into the right-of-way. That is deal with Public Works and make sure that that is in alignment with Public Works requirements. Thank you.
Applicant?
Good evening, everyone.
Good evening.
My name is Valencia Delalu. I'm living at 30 Northwest 121 Street. The driveway is existing driveway. I don't mean to do it like that, but it was like that. I just rebuilt. If you see that in the parking lot, that's the way we enter to park in the carport. So when I did the fence, I take the permit, but I didn't know if I'm supposed to take 5 feet, because it was like that. It was like that since I'm living there. I never have problem with it. After I finished build the fence, but it was cracked, I just rebuilt to make it nice in my environment, you know. But I don't mean to. I don't know if that's gonna cause all that problem. I should leave it the same way it was. It was cracked and very dirty, very dark. That's why I'm trying to rebuild it to keep it nice and clean. And then that's the reason I'm here today. And then only one chance I have. You don't have to help me to keep it. Without that, I cannot park the car. Is that the entrance? Is the way we have to entrance to the parking lot? It was there like that long time ago. That's the same way. I don't do nothing. I don't put nothing. I don't add nothing on it. If you can see the picture, you see what I'm talking about. Thank you for your cooperation.
Thank you.
Thank you.
I'll open public hearing. Anyone for or against?
Hello again. Good evening, board. I did observe her driveway. She has a permit she submitted in the building department. So this is how this came about, because the configuration of the driveway that she replaced would not, if she were to have the 5 feet setback, it wouldn't align with the carport that's aligned with her home. So this is why she's going forward for a variance. But she does have a permit application that's on file, and it's awaiting your decision regarding the variance to move forward. So if she were to have the 5 foot, it would be almost a hardship, because she would have to cut the concrete in order to be in compliance with the 5 foot. So it's she's in a dilemma here. All right, thank you.
Thank you. Public hearing is now closed. Board discussion. Would we like to see the picture of the front of the house with the slab there again? Maybe that will help us.
That would be very helpful.
Sorry, Mr. Cook.
That's quite all right, ma'am. I'm hoping that we have one in the packet.
No, it's the one with the.
There was one in your
the picture
presentation.
with the front of the house. I
see.
guess the beginning of the cover page of your presentation.
Yeah, okay, yeah. Yeah. That's that on the right side of our picture. Yours, I guess, is on your left. They bring it up.
There she is. Okay.
Yeah.
Okay.
That's the mobile.
Yeah. Okay. Okay. No discussion?
I move to approve based off of the 2 recommendations of staff.
And I'll second.
Thank you, gentlemen. Moved by Mr. Shields and seconded by Mr. McDermott. Roll call.
Chairwoman Philippe, how do you vote?
Yes.
Board Member McDermott?
Yes.
Board Member Medina?
Yes.
Board Member Pierre-Louis?
Yes.
Board Member Shields?
Yes.
And Board Member Joseph.
Yes.
Item approved.
All right. Good luck. I hope it's better now. All right. Any old business?
So we have a discussion item, madam, that you requested of me a few months ago.
Oh, yes. Quick.
Quick. So we had the North Miami Transit Station Overlay District. So what we have going on here, it was a request of the chairperson dealing with the Johnson Wells property. You know, recently, unfortunately, Johnson Wells left our community, and it became bought by one group, and they sold it off. So what you had there is, when they sold it off, it's all PU. What's PU? Public use. Public use is what it says. If you're gonna do anything there, it's got to be public use, such as maybe a community complex, city hall, something to that effect, your motors, vehicle services for the city, things to that effect there. So what you have is, you had when the school left, you had a lot of non-conforming uses going on there. Specifically, you had people who wanted to convert the residential student housing into apartments. You can't, because we don't allow for residential use there. So the concept was to go and have a rezoning from the PU to PD3, which is this map right here is an illustration of what the PD3 would look like when we put it in over all of this Johnson Well area. And so we was going forth with this to change it to PD3. PD3 would allow for you to have a mixed-use development, at least 3 uses, and one of them have to be residential, and it also allows a maximum density of 45 units per acre, and you have 110 feet as your maximum height. You could also seek to do a conditional use would have added 25 more units to that per acre, and you can go on for that through the conditional use permit. So we was moving forward, and then it was scuttled. We would have done that. You produced a lot of different things, but it was scuttled. It was stopped. And this is what we had that actually is going before City Council at its next meeting. And it is to extend the North Miami Transit Station Overlay District from Northeast 124th Street all the way up to Northeast 127th Street. And what would that introduce to the area? That would allow for a maximum height of 200 feet and allow for a density of 150 units per acre for that area of the city. The remainder of Johnson Well will be determined as we go through our comprehensive plan process right now that we are getting ready to renew it. We're at the 7-year period on that, and doing our outreach to the different communities and things to that effect. We'll hear from them on what they would think the zoning should be for that area, and based on that, we would introduce that into our comprehensive plan. And then subsequent to that, next year we'll be going through revisions of the land development regulations to correspond with the adjustments that we make to the comprehensive plan, and that would be executed at the end of the year that way for the remainder. This item will be, like I said, on the next agenda for City Council for first reading, then you'll have second reading, and then you'll be moving forward. What this will create, though, is you're looking at approximately at 150 units per acre. You're looking at 1,794 potential units will be in that area. And you're looking at available floating units that we have in the city right now. All of those units to be activated would have to go through the conditional use permit process, which will require going to the Planning Commission and then for recommendation, and then to City Council for approval. In a nutshell on that, I say if you as a developer had a lot there and you wanted to develop it into a mixed-use development with residential, you'll need a conditional use permit approval to get any of those units there on whatever the maximum may be for your lot. Let's say if you had an acre lot, then you'd be able to do 150 units at that location. And there you go, and you did that. And that would come out of these floating units that we have available of this 2295 right there. And that's where it is. That's where we are, so you can know where we are going forward with our development of the JWU area formally. That's the presentation. Any questions?
I still see the focus is more on residential use, and still, we're still out there with business.
So it would allow for, what you have is mixed-use development. Most people, developers we have who have come in, earlier when I talked about the Mount Biscayne development, that's a mixed-use development that is within the North Miami Transit Station Overlay District. That's right at 124th is the north area of that property. And they are doing a mixed-use development of 300 and some odd units with retail on the ground floor of several different uses that is taking place there. That's generally what is the case. Unlike in our North Miami redevelopment overlay district boundary area and in our planned corridor development areas overlay, they require for mixed use. The North Miami Transit Station doesn't, but everybody does it who we have had come before us does a mixed use development.
And I know, as an old business, there was something that we voted upon. It was supposed to be a childcare, but now I see that what they put in there is a medical facility, like a center.
What was this, Madam Chair?
That was on West Dixie. That property, standalone property that's near the theater, the old theater.
Mm-hmm.
Yeah, we voted upon for childcare center, but then they
So,
turned.
so what happened there, if I may, is they were moving forward, coronavirus hit,
I know, that's where
and
the
they
money
killed
is.
them. They killed them. Yeah, they couldn't move forward with it.
All right. Any new business? Okay. Question?
Didn't we used to have computers?
For here?
Yeah.
No. That was always for
That's
council.
Okay.
That's why I take my notes. Mm-hmm. Because I'm not bringing my computer. All right.
I have a question.
Do we have more?
Yeah, we
Ms.
have a
Medina, I'm sorry.
I have a question. So, excuse my ignorance on this process. So, this is being presented, what you spoke about, and what are we doing regarding what you just presented? What are we doing? Are we going to vote on it, or?
No. It was
Okay.
just so that we are aware of what's happening, because maybe some things might come in front of us down the road based on the changes that's going, because they're rezoning certain things and allowing things to come in.
It's just an FYI.
Yes, FYI.
That's it. Okay. All right.
Okay. All right. Motion to adjourn?
So moved.
Yeah, second? All in favor? Aye. Okay. Let's put this
Happy
back together.
Juneteenth and happy Father's Day to everyone.
Oh, thank you.
By the way, we should welcome Cameron and Isaiah.